The Immigration and Nationality Act of 1965, also known as the Hart-Celler Act, abolished the quota system established in 1921, expanded upon in 1924, and largely unchanged since then. After a contentious gestation during the early 1960s, the Hart-Celler Act was signed into law by President Johnson in October of 1965. This act focused on reuniting families and sought to attract skilled laborers who would increase the gross domestic product and enhance competitiveness of the U.S. in the global marketplace. Over the next 4 decades, the policies put into effect in 1965 would greatly change the demographic makeup of the American population, as immigrants entering the United States under the new legislation came increasingly from countries in Asia, Africa, and Latin America, as opposed to Europe. The act provided for preferences to be made according to categories such as relatives of U.S. citizens or permanent residents, those with skills deemed useful to the United States, or refugees of violence or unrest. Though it abolished quotas per se, the system did place caps on per country and total immigration, as well as caps on each category. As in the past, family reunification was a major goal, and the new immigration policy would increasingly allow entire families to uproot themselves from other countries and reestablish their lives in the U.S. The next major round of immigration reforms would occur under President Ronald Reagan in 1986 and President George Bush Sr. in 1990. In 1986, under President Ronald Reagan, the Immigration Reform and Control Act attempted to increase enforcement of immigration laws and provide pathways to legal immigration. These reforms are referred to as the Amnesty Act because it extended protections to immigrants that entered illegally but did little to stem the flow of border activity. The act included 2 amnesty programs and collectively granted amnesty to more than 3 million illegal aliens. While there are many facets to an intelligent immigration reform package, one thing is clear: legalization for undocumented immigrants helps all of us. Most economists recognize that legalization has worked in the past. IRCA provided unexpected indirect benefits to the communities where legalized immigrants resided. President George Bush Sr.'s 1990 Immigration Act modified and expanded the 1965 Act by establishing TPS, or Temporary Protected Status. It also formalized his Family Fairness Policy as the Family Unity Program that remains in effect. These policies provide family members residing with a legal immigrant and who were in the U.S. prior to the 1986 immigration law were protected from deportation and granted work authorization. The order extended the number of visas granted based on familial ties in an effort to expand family reunification efforts. The law also provided for the admission of immigrants from underrepresented countries to increase the diversity of the immigrant flow. The next major development would come in 1996 under President Bill Clinton. The Immigration and Nationality Act of 1965 abolished the quota-based control of immigration established in 1921. In 1986, the Immigration Reform and Control Act created legal paths to citizenship, at the same time strengthened enforcement of immigration laws. The 1990 reforms emphasized cohesion of immigrant families and encouraged immigrants from underrepresented countries. Through all these changes, the notion of public charge, or being a burden on society, remained a force in immigration policy. Federal officials can deny entry to the U.S. or adjustment to lawful permanent resident status to someone they determine to be a public charge. Lawful permanent resident status is also known as LPR, or green card status. In 1996, under President Bill Clinton, the Illegal Immigration Reform and Immigrant Responsibility Act was passed, addressing the enforcement of national borders and the use of social programs by immigrants. It further limited the extent of services provided to immigrants by the government so as to reduce the possibility of immigrants becoming public charges. The extent to which the use of public services contributes to a public charge, and therefore could lead to deportation, is up to the discretion of prosecutors and judges. Border, immigration, and customs enforcement operations are being overwhelmed by the volume of immigration cases to be pursued. When the federal government has attempted to keep up, the legal system has become clogged with a backlog of pending cases. The effect of those efforts did not stem the inflow of immigrants and hampered the outflow. This strained outcome was seen in the aftermath of the Trump administration's child separation policy and Title 42. Determining what constitutes being a public charge had long been a discretionary function of law enforcement. When strict enforcement was attempted, the result was a legal system clogged with a backlog of pending cases. Clinton-era policies revoked prosecutorial discretion that had led to logistical and economic problems with other low to zero tolerance policies. The Department of Justice made an effort to mitigate concerns over flooding of the immigration court system. Interim field guidance, put in place in 1999, established a priority system for law enforcement officers to consider when evaluating immigrant reliance on public support. These guidelines said an immigrant was a public charge if they had or were likely to become primarily dependent on the federal government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalization for long-term care at government expense. There had been confusion about whether the use of Medicaid, the Children's Health Insurance Program, known as CHIP, and other non-cash programs counted as a public charge. The guidance clarified that immigration officers should not place any weight on the receipt of non-cash public benefits other than institutionalization with respect to determinations of admissibility or eligibility for adjustment to LPR status. This expanding and contracting of the definition of a public charge is as much at the heart of the immigration debate today as it was back then. It remains essential to determining what qualifies as merit for receiving a visa, temporary protected status, or lawful permanent residency.